Without further ado, I think we should move on straight to the first case study. Excuse me. And this case study we call the sleeping fighter case study, and deals with a situation of non-international armed conflict, as do the two other case studies, where we have an individual who's part of a group who happens to be at home in a particular evening. And the question there is, what kind of force can be used? So without further ado, I'll ask David to take us through the first questions on this particular case study, and thereafter invite each of the panelists to give their comments on the particular case study. David, over to you.
Thank you, and good afternoon to you all. In order to deal with the study, it is very important for us to deal with the actual assumptions behind the case that we've been presented with. Our assumption is that we do have a non-international armed conflict taking place in the territory of the state concerned, but that the hostilities in this conflict are only restricted to some parts of the country. And this situation forces us to contend with two competing legal regimes that regulate the use of force by a state in its own territory. The primary legal regime would be the law enforcement or policing regime, based on domestic law but always subject to the state's international human rights organizations. We may call that the lex generalis, the general law that applies to the use of force by a state in its own territory. But alongside this regime, in a situation of armed conflict, we may have application of an armed conflict regime that applies in the case of hostilities. This would be the lex specialis in that situation, which would apply only to the hostilities in the armed conflict. Now let's start with the differences, and it's very important to understand the implications of using one regime rather than the other. If we are talking about the policing regime, we are talking about use of lethal force only when absolutely necessary to protect persons against unlawful violence. And this means generally that only when faced with an imminent danger of such unlawful violence, when there's no time for use of other non-forcible means such as arrest, may force, especially lethal force, be used by the law enforcement authorities. In fact, one could say that force in this case is conduct-based. It's only based on the conduct of the person against whom we intend to use force. If we are dealing with the hostilities model on the other side, we are talking about a distinction between combatants, or in this case of a non-international armed conflict, we should rather refer to them as fighters, and civilians. The fighters may be targeted as long as they have not been removed from the combat. And it is their duty, if they wish to remove themselves from the combat, to make this clear by surrendering. We do not have to wait until there's an imminent danger before using lethal force against fighters or combatants. In this case, the use of force is generally status-based rather than conduct-based. So now we have the dilemma in this case. If we are saying that because there is an armed conflict going on in the territory of the state, and we may apply the hostilities model, then force may be used even if this individual may reasonably be apprehended without the use of force and without undue danger to the law enforcement officials of the state involved. If, on the other hand, we say that we are going to use the policing model, then an attempt must be made to arrest the individual, and only if it becomes necessary during that attempt to use force may force, possibly lethal force, be used. Now, in order to resolve this dilemma and to decide which model is appropriate in these circumstances, we have to pause for a moment and remind ourselves how we reached the conclusion that a non-international armed conflict is actually taking place. Well, a non-international armed conflict in the territory of a state takes place when two major factors are in existence. The first relates to the level and scope of the resort to armed force. Only when we have a fairly high level of resort to armed force may we say that we have an armed conflict, and that must be joined with the level of organization behind use of that force. This is clearly brought out in the additional protocol number 2 to the Geneva Conventions, which relates to non-international armed conflicts, and especially states that it does not apply to situations of internal disturbances and tensions such as riots, isolated and sporadic acts of violence, and other acts of a similar nature as not being armed conflict. Any justification of resorting to that regime outside the actual context, and I stress the context of hostilities. And there are two views here. Some take the view that since an armed conflict is going on in the territory of the state concerned, and that that individual is a fighter of the organized group which is involved as a party in the armed conflict with the state, as long as he is not surrendered, he is to be regarded as a fighter and may be targeted at any time. I do not take that view. I believe that as we are talking of a non-international armed conflict, the state still retains its primary human rights obligations to ensure the lives of those subject to its jurisdiction. When dealing with actual hostilities, obviously the policing model is neither appropriate nor relevant, and the state may resort to the hostilities armed conflict model. Thus, we have the demand in the definition of a non-international armed conflict for a certain degree of armed violence and organization, which would seemingly make the use of the policing model unfeasible. But outside the context of hostilities, the state may not use the very formal existence of an armed conflict in its territory as an excuse to abandon the policing model and use force or lethal force in those circumstances where the person can reasonably be apprehended without undue danger to the authorities involved. The second question asked was, well, does it depend on the zone? And I don't think that we should make a rigid distinction between different zones. The question is not the zone, the question is the context. Are we dealing with a context of hostilities, in which case the appropriate model is the hostilities model, and which it's obviously not feasible nor reasonable to require that a fighter be arrested and the use of force is going to be appropriate. But if we are talking about a context in which hostilities are not taking place and it is reasonable to arrest the individual, even if formally it may be in the zone of hostilities, I do not see justification for resorting to the hostilities model. We've also been asked, are the level of control and the level of violence relevant factors? Certainly. The higher degree of actual control and the lower the level of violence in a particular context, the less justification there is for the state resorting to the armed conflict model. I think I'll stop there and let the other participants take over.
David, thank you very much for the first few comments and answering those questions quite directly. Before I turn over the floor to, or the microphone should I say, to other panelists, Richard next, I take it then therefore that very much you're looking at the situation of as long as we're speaking of a context outside of hostilities, we are using a law enforcement / police counter paradigm rather than the conduct of hostilities, which of course, as the other panelists will touch upon, will have an impact in terms of how we assess questions of necessity, proportionality, and the likes. So Richard, if I may put the same questions to you, and feel free to already respond to some of the points raised by David.
No, I mean, obviously we take a different view on the use of force against the sleeping fighter. I mean, it's very controversial, but the historic traditional view has been that in armed conflict, fighters may be targeted at any time, and so members of an organized armed group or those who are part of a uniformed military can certainly be targeted at any time. So we don't And that's been the historic view for a long time. So we would certainly disagree with that. I mean, that seems harsh to folks looking at the outside, you know, the poor sleeping fighter. But if you think about the fact that that individual will rise to you know, the next day and go back to the fight, then that certainly I think somewhat changes the analysis there.
And Richard, if I may, to you, does it make a difference at all if we are, and as part of the second and third questions here in this first case, the question of control over the territory, the greater the control over the territory, the greater the requirement potentially to move towards a law enforcement situation?
I mean, we don't, Jamie. I mean, you know, we see it as if we're in armed conflict, then it's armed conflict, and the lex specialis would apply there. Now, there's certainly just a host of operational reasons, of policy reasons to capture rather than kill. I mean, that's you know, we always seek to capture as a matter of policy, as a matter of operational urgency when we can, because that's just there's a wealth of information you can get from a detainee through interrogation. It's certainly you tend to alienate the population less. And so there are good policy and command reasons, operational reasons to capture if possible, and that is in fact we tend to do that quite a bit. But I don't see it as a legal requirement that you must capture than kill.
And in that case, I'll ask Gloria to step in at this stage and to address some of the issues that have already been evoked by both of which.
Thank you, Jamie. So thank you. It was very interesting to hear the views from David and Rich. And I think that what they told us today shows how much controversial this first case study is. And it indeed was also during the expert meeting of the ICRC. I would say that there is no perfect answer to this case study, because we can see strengths and weaknesses in the different views which were exposed. So let's have a look first maybe at the law enforcement approach, the one which was presented by David. I would say that the strengths of this approach definitely is that it's more protective from a humanitarian perspective. When we look at case study 1, we think, okay, this isolated sleeping fighter, is it fair to target and kill him under the conduct of hostilities while it's a particular situation where capture would be feasible and probably not endanger the attacking forces. So it's more protective, and that's a big strength of this first approach. However, I see also many weaknesses in this approach, and probably the main issue is that the legal basis for saying that in a non-international armed conflict where IHL applies on all the territory, as demonstrated by the ICTY case law notably, then in particular situations it would be the law enforcement paradigm which would prevail over the conduct of hostilities paradigm. So the legal basis is shaky. During the expert meeting there were two proposals. One proposal, which was not exposed today, was to consider that human rights law and the law enforcement paradigm could be the lex specialis and prevail over the conduct of hostilities under certain circumstances. Another view was that the law enforcement paradigm could be the default legal paradigm. And if I understand well, what David presented goes in that direction. When, David, you say that human rights law and the law enforcement can be seen somehow as the lex generalis. And so according to these different views, the idea would be that under some circumstances, the law enforcement paradigm would prevail. But then the big question is, yes, but when? What are the criteria? That's always the issue. We can understand that in some circumstances it would not be the conduct of hostilities, but then we need to know very precisely what are these circumstances. And very often these criteria are not provided. During the expert meeting we tried to discuss some criteria, some possible criteria. In the background paper provided by the ICRC, we asked the question whether the conflict zone, the notions of control over the area or intensity of violence could play a role. So if I may give some more detail on these criteria. For the conflict zone, the idea was that everything depended on the location of the isolated sleeping fighter. If the isolated sleeping fighter would be in a conflict zone, that is to say a zone where hostilities are taking place, then the conduct of hostilities paradigm would prevail. On the other hand, if the isolated sleeping fighter, as in case study 1, would be outside this conflict zone, then the law enforcement paradigm would prevail. That was one possibility. The other possibility was to look at the control over the circumstances and area and the intensity of violence. That is to say that if the control over the area where the isolating sleeping fighter is huge, and at the same time the intensity of violence is low, then the law enforcement paradigm would prevail. These factors were discussed during the expert meeting, but they were criticized by most of the experts as too vague. If I may quote some of the adjectives which were used during the expert meeting, some experts that said that these criteria or factors were too subjective, too open to debate, and misinterpretation or disagreement. So the main criticism was to say it's too vague. We cannot rely on these criteria to decide whether it's conduct of hostilities and law enforcement. So if we reject those criteria, what could we replace them with? And I think, David, you propose the notion of context of hostilities, and I would be curious to know what we mean by context of hostilities, what kind of criteria you would use to say this is a context of hostilities or this is not. Also, the argument to say that the law enforcement paradigm prevails often rely on a diverging approach between international armed conflicts and non-international armed conflicts, or more precisely, internal armed conflicts in a case like case study 1. However, the problem of introducing such differences between international and non-international armed conflicts is there. It could be indeed dangerous or counterproductive. Let's think about all the evolutions in international humanitarian law. Nowadays, I think everyone considers that under customary law, the principles of the conduct of hostilities apply equally in international and non-international armed conflicts. So how could we reconcile that with this huge distinction we would do between international and non-international armed conflicts when it comes to determining the appropriate paradigm? There is also a problem regarding the equality of belligerents in such a case, because why, in the case of the isolated sleeping fighter, it would be the law enforcement paradigm, but the reverse, i.e. the isolated sleeping soldier, would not be protected equally under this approach. So basically, there are a number of questions when we try to explain why the law enforcement paradigm would prevail. I will now take a look at the other approach, the conduct of hostilities approach. So the strength of this approach is that it's fairly clear, simple, and straightforward. The idea is that under in armed conflict situations, international humanitarian law is the lex specialis, in particular when it comes to conduct of hostilities issues. So there would be basically one main criterion to distinguish between the conduct of hostilities and law enforcement paradigm, and that would be the status, function, or conduct of the persons against whom force may be used. In other words, you need to determine whether the person is a legitimate target under IHL. If the answer is yes, then it's conduct of hostilities. If the answer is no, then it's law enforcement. So here we have no problem of equality of belligerents. And it's the same approach for international and non-international armed conflicts. So that's a strength. The weakness is that in an exceptional case like case study 1, we have to say that the result is disturbing. Because to think that you can target and kill the isolated sleeping fighter, even if you could capture him, is counterintuitive. So what can we do faced with this dilemma, as David put it? Well, one proposal from Richard Gross was to say, well, a reasonable military commander would command a capture operation for policy reasons. But is it sufficient to talk about policy reasons? Isn't it too weak? Because at the end, it leaves total freedom to states to do whatever they think is convenient. So I will not solve this issue today, But I would say that at the very least, even if the conduct of hostilities paradigm were to be chosen in a case like case study 1, then we need to take into account the principles of military necessity and humanity. And these principles would lead to a conclusion that in an exceptional case like case study 1, a capture operation would be prescribed, or at least means which would be other means than lethal means would be prescribed. This is not to say that there would be a capture rather than kill approach under the conduct of hostilities paradigm, but rather, because the presumption is the reverse, the presumption would be that you can target and kill a fighter in a non-international armed conflict, wherever that person is, but that in exceptional circumstances, when there is no military necessity to attack that person in order to put him or her hors de combat, and the principle of humanity commands you to take that person hors de combat by other means, then you need to do it. Thank you very much.
Thank you very much, Gloria. So we have quite a few issues have been put to us already in the past 50 minutes in the first case study. I am going to give the floor back to David, because I think there have been a couple of positions in opposition to your position. And I also have a question from one of the attendees, if I may. And if you wouldn't mind also addressing that particular question. And after David, I'll turn the floor and the mic to Richard, who has also received a question with regard to the battlefield component. But David, before I give you the mic, just to let you know, one of the questions we have received from one of the attendees is whether or not you could explain what provisions from IHL or human rights law you base your position on, i.e. what is the legal basis for your interpretation. So David, if you have any answers to the other two panelists and to that particular question, the mic is yours.
Thank you very much, and thank you for the other panelists for their incisive comments. It is quite clear that there's a major disagreement between me and Rich, and that is quite natural. But let me start with an answer to the specific question that was asked. And my clear answer is an answer that the legal basis is the duty of the state to protect the right to life of all individuals subject to this jurisdiction. According to the view of the International Court of Justice in the nuclear weapons advisory opinion, this provision continues to apply even in times of all armed conflict, international and non-international. And it certainly applies in the territory of a state. And so the legal basis was that the state has a duty to protect the right of all those persons. It may only depart from that when the taking of life is not arbitrary. And then we are taken back once again. It's a kind of vicious circle to the question, well, is it arbitrary? And in order to decide whether it's arbitrary, we have to decide, is it lawful under the law of armed conflict? And so I come back to the issue of the law of armed conflict. And here Rich has spoken about the traditional view. But here I have my doubts about the traditional view, because the traditional view has been the view in international armed conflicts, where we have a clear distinction between combatants and non-combatants. Combatants are defined under customary international law. They must wear uniforms and an insignia which could be recognized from afar, and they have certain privileges. We do not have any definition of combatants, and certainly no privileges for fighters or combatants or whoever, what you want to call them, in non-international armed conflicts. In fact, to this day, there's even some discussion of whether we have a special category of fighters in non-international armed conflicts. There are some who take the view that in non-international armed conflicts, the only distinction is the distinction between civilians taking part in hostilities and those who are not taking part in hostilities. So the parallel between international armed conflicts and non-international armed conflicts is somewhat restricted. Second of all, there's a great debate about the relationship between the law of armed conflict and human rights law. Now that debate in my mind becomes especially serious in international armed conflicts and even in transnational armed conflicts, which may be with non-state actors. But when it comes down to an armed conflict taking part within the territory of a state party to one of the treaties, or even under the human rights treaties of customary international law, it is clear, and this the International Court of Justice has also made quite clear, that the state is not freed from its international human rights obligations. They continue to apply, and hence the right to life. Now, the big question, of course, is obviously the question of vagueness. But here is my problem. The very definition of whether we've passed the threshold of violence required in order to typify a situation as a situation of non-international armed conflict, those criteria are themselves vague. And to a large extent, it's first and foremost for the state involved to make the initial assessment of whether we are talking about a non-international armed conflict or not. And on policy grounds, I would be very reluctant to give over to the state, first of all, the judgment of whether a non-international armed conflict is taking place, and then to say once you've actually characterized the situation as an international armed conflict, you can even use lethal force against persons who you may reasonably be able to arrest without any danger to your security forces. Now, I'm making this clear. I'm not saying that you have the pure policing model. We do have an armed conflict taking place, and we are not going to subject our armed forces to undue risk. And so if there is a real risk that in trying to arrest this individual, they are going to be attacked, they may use force. But we are talking in our assumption of such a situation where there is no such risk. So the vagueness applies whether you're talking about actually categorizing the situation as a non-international armed conflict or dealing with a specific situation, or whether you're dealing with law enforcement or not. We can also get around the situation of vagueness by creating burdens of proof. What is the assumption? Yes, we have an armed conflict going on, and our assumption could be that in that situation, if we are talking about a fighter, you may use the rules relating to hostilities, unless it is clear in that situation that you could reasonably arrest the person without any danger to your own troops. Now, in response to Rich as well, I am not saying that you just have to do nothing about this individual. As you said, from a policy point of view, you would probably prefer to actually arrest the individual involved and possibly be able to get some information from him. But even if you don't get any information from him, you certainly can neutralize him as a fighting force. Now, as far as the application of international humanitarian law in the whole territory of the state involved, and clearly that is the view, certainly it's the view taken by the International Criminal Court for Criminal Tribunal for Yugoslavia, that international humanitarian law applies in the whole territory. But here I think there's some confusion, because use of the term international humanitarian law has a connotation of protection, and all the cases in which it has been decided by the International Criminal Court for the former Yugoslavia that international humanitarian law applies in the whole territory have been cases in which it wants to extend the protection of humanitarian standards to persons who in places in the state which are not involved in the armed conflict. One has to go quite a long way in order to say that according to this logic, not only are we going to extend protection to persons outside the context of hostilities, but that we're going to subject them to the use of force which is in no means necessary. I would say that I do have a bit of a further support for my view. It was adopted by the Supreme Court of Israel in the case in which it examined the use of force by the Israeli forces against persons who were involved in hostile activities against the State of Israel. And there the court did say that if it is possible to arrest the individual, that must be the approach used, and lethal force must not be used. I think I've taken up enough time, so let's hand over to the others with the other questions. Thank you.
Thank you very much, David. Again, you raised quite a few questions here. And Richard, of course, I'll give the mic back to you and also give to you one of the questions that the attendees sent to us with regard to the question of the sleeping fighter. And to quote what this attendee said, and the question is, where do you draw the line as to whether the sleeping fighter would indeed be back on the battlefield the next day? What criteria do you use? Who determines what is applicable? As long as the sleeping partner or fighter is not on the battlefield, he is off duty, and his vulnerability, off guard, should not be the basis for attack. And there's that part of the question. Of course, there's part of the response maybe to David's issue here that the protective nature of IHL, in particular Common Article 3, means that conduct of hostilities issues should not fall within Common Article 3 in the first place. So Richard, over to you.
Yeah, thanks, Jamie. I mean, the first thing I would say is the question and some of the language that Gloria used and others have used, and certainly the experts. I mean, there's a certain sympathy with this poor farmer who's sleeping at night with his family, and he's isolated and he's nowhere near a weapon, and oh my goodness, how can you walk in and just in cold blood shoot that individual? How could that possibly be allowed under the law? And the fact of the matter is that situation almost never happens. Typically, you know, and the question from the individual in the audience kind of has that same idea. Like fighters, you know, they clock out at the end of the day and they're no longer a fighter, and they go home and they're just this farmer, and certainly there are farmers who go out during the day and fight for insurgencies and fight for the Taliban and or whatever, and it's a one-time thing. But the majority of the time, these are individuals, and the ones I was speaking to were members of an organized armed group, you know, and who their role is to go out and kill, you know, your soldiers, and so you have to take that into account. And certainly any commander who was inside a building, perfectly safe, surrounding the bed of this poor innocent fighter, I can't imagine any of the commanders or soldiers I've ever worked with over 29 years would sit there and then cold blood shoot that individual. They're going to capture him. I mean, I'm absolutely certain about that. But is that a legal requirement? And the law should reflect what the law is, not what we want it necessarily to be or what people think it ought to be. And so as you look at the legal requirements of the law of armed conflict, then I think there, and I'd point you to a great article by Chris Jenks, Jeff Korn, Ashley Deeks, and some others who have written extensively on this least harmful means rule. And you know, I'd point you to some of their writings for an in-depth exploration of this. Most of the time, what we have is a fighter who, you know, is if they have the opportunity, they're going to pull a gun and come back after your soldiers. So there is a great deal of danger that you face on the battlefield. There's very few objectives where the poor innocent sleeping fighter is just, you know, is just going to be there, and you're going to absolutely be able to overwhelm him most of the time. So you know, I just kind of push back upon some of these fact patterns that people tend to roll out in these kind of settings to make it sound like you're just the most inhumane person in the world when you follow this rule. So I think certainly there are policy reasons where you capture if you absolutely can. I just don't think there's a legal requirement, and nobody's been able to point to a legal requirement to my satisfaction to show me that yes, this is the rule. I mean, most of the time, and even David, I think, pointed out that, you know, one of the primary factors here is the risk to your own forces, and in most cases there is extraordinary risk to your own forces. You know, there are certainly booby-trapped houses, there are weapons, there are guard forces, etc. And so it's a rare situation where you actually have, you know, this poor sleeping fighter alone in his bed or with his family, unarmed, just unable at all to threaten your forces. It's just not realistic in the modern warfare that we've seen. And we shouldn't write law, we shouldn't create law to cover that rare situation. You know, the law ought to reflect really the realities of combat and state practice in combat, and that's what international humanitarian law is. So I kind of push back on this particular fact pattern of this case study, because it is kind of it's geared as to be controversial and to evoke some sympathy, and it perhaps not as realistic as what we see on the modern battlefield.
So thanks, Richard. And in particular, I think the point that you underscored with regard to the distinction between law and policy, and the shall and the should. I can turn the mic over to Juan Carlos, who wanted to intervene on this point. Juan Carlos, can you hear me?
Yes, I'm hearing you. Okay, yes, I want to say something based on the experience we have here in Colombia with 50 years of non-international conflict. And that is that, yes, if you analyze this case legally, yes, you can attack. But based on the experience, I think that if that happened today in Colombia, before making any decision, the commander will try to capture this person. If not, if he needs to attack, he will have a very clear explanation to justify this attack, and they will have to have all the information to give to the judge and try to justify why he made the attack, instead trying to capture this person. And I'm saying that because, as I told you, that is what is happening right now. And if you make the decision to attack, for sure, and if you kill this enemy, next day you will have to confront the judge and try to explain him why you made the decision to attack instead to make the decision to capture him. And if you have all the information, like the general said, in the sense that, yes, it was very dangerous, I could put in risk the troops, and that was the best decision, to attack instead trying to capture him, then you can solve the problem. But if not, for sure, you could be in trouble. So I think that independently, if you are in the paradigm of hostilities, if you can to capture instead killing, I think that is the best way to act.
Excellent. Thank you very much, Juan Carlos, for that. And again, going back to the question of the accountability, of course, of those on the ground, of the soldiers who have to take those decisions and make the choice between quite often what is a life and death situation, and the review post-action of their actions, in particular when we're looking at the loss of life. At this stage, I'll turn again the mic over to Gloria for a couple of comments, and then open it up for a couple more answers to some questions we've received before we move on to case study 2. And I think particularly, Gloria, there was a point that Rich came up with on a couple of occasions, a question of the Section 9 of the DPH study, and the question of, again, the legal statements or not, as the case may be.
Thank you, Jamie. I have actually two questions. The first question goes to David, because if I understand well, then the new criteria we could use would be the same criteria we use for the qualification of a situation as a non-international armed conflict, i.e. the criterion of organization of the parties and the criterion of intensity of violence. So that would mean that each time, even when you are in a non-international armed conflict, you have to check whether those two criteria are fulfilled in order to determine whether it's conduct of hostilities or law enforcement. Is that right? That's the first question. And a second question to Rich Grotz and Juan Carlos Gomez. It's about the factors that we discussed during the expert meeting of control, intensity of violence, and conflict zone. In your experience, in your operational experience, would you say that these factors, even though they are not legal criteria, so that they cannot be put on the same footing as the status, function, or conduct of the person against whom force may be used, are these factors nevertheless useful, used in contemporary military operations? For instance, I have an example. When we look at the principle of precautions, if we are going to conduct an attack against a military objective in a zone which is really controlled by the army and where the intensity of violence is quite low, then probably that there will be more feasible precautions to be taken in the choice of means and methods of attack. So in one word, could we say that these notions are factors that need to be taken into account when applying regular IHL rules? Thank you.
Well, it looks as though we have a couple of additional questions. So we'll give ourselves about 4 or 5 more minutes on this particular case study. And I think there are 2 specific questions put forward by Gloria, I think to David, Juan Carlos, and Rich as well, I think, has been asked to address these. So in that particular order, David, Juan Carlos, Richard, feel free to answer those questions and to respond to anything else that was said. And thereafter, unless I have any other questions coming from attendees, I'll close the round on this particular case study.
Let me say that I agree with Rich that this particular case study is an extreme case which is not likely to occur in actual practice, but it is a good case, as we law professors use these kind of cases to examine the actual questions of principle involved. Now, to answer Gloria, I am not saying that in each individual case one has to go back to the actual definition of a non-international armed conflict and see whether it applies in a specific situation. I'm referring to the rationale of defining a given situation as a non-international armed conflict as opposed to a situation of riots or disturbances. And the rationale is that when we have passed beyond a situation of riots and disturbances which can be dealt with by policing, then there is justification to go over to hostilities model. That is the whole justification for even deciding that we have a non-international armed conflict. So I'm using the policy behind the actual notion of a non-international armed conflict in order to reach the conclusion that when it is entirely feasible still to use a law enforcement model, the state cannot adopt the law enforcement model and use the excuse that an armed conflict is going on in order to use lethal force in a situation where it is not justified under the laws of law enforcement.
Thank you very much for that. Juan Carlos, anything you'd like to add?
No, thank you. I have nothing to add.
Excellent, thank you. And Richard, any last words?
Well, I would just, in response to what Gloria said about the level of control and the level of violence in a particular area, or the intensity of combat in a particular area, Juan Carlos's comments about making decisions about the use of force, I would have echoed those exactly. And these are areas where the level of the intensity of a conflict in a particular area, the amount of danger to our forces, the amount of control over a particular area, or how much our forces are in a particular zone, a particular district, etc., is going to make a difference in how commanders decide what level of force to use as a policy matter, as an operational matter, whether to surround the compound and ask the individual to come out, whether to send in local national forces, police forces maybe, or perhaps local security forces, or whether to use lethal force in the first instance. And those and so while those factors that Gloria raised, certainly every commander considers those in making a judgment call on whether or not to use lethal force or capture. Again, I don't think they affect the legal determination at the end of that. And I was really struck by Juan Carlos's comments. He was speaking of Colombia. I was thinking of Iraq and Afghanistan, but I think we virtually would have given the same answer to that particular question. So I found that very interesting.
Excellent. Well, thank you very much. And so I think that first case study, as much as it's seen as a bit of an extreme fact pattern, gave rise nonetheless to quite a few realistic legal and operational dilemmas. And I think the 4 panelists so far have done a very good job in terms of identifying what some of the main issues are and some of the main trends. I felt that the points with regard to the relevance of IHL in non-international armed conflicts and the purpose of IHL to be quite interesting, but also in particular with regard to the legal right to do something and deciding as to whether or not to take and use force, to take actions that could lead to the loss of life, to be instructive as well. So as you could, for the attendees and those listening into this webinar, you can only imagine what the expert meeting would have been like a couple of years or so ago, because these are quite realistic situations, and there is still much to be discussed, no doubt, before we have a full consensus on this particular scenario.